I think animal crimes are certainly important in and of themselves. I think the way that we treat animals speaks volumes about who we are as humans.
These are often sort of precursors or links to much more serious cases that the community very much has an interest in stopping.
They do not exist on their own. They just don't.
If you haven't been able to collect the evidence that we need to proceed, then that puts us in a difficult position of, hey, we want to go forward, we want to win this case, but our chances of doing that are extremely minimal. It's challenging to motivate prosecutors if they're getting cases that they don't see very often.
Some of those prosecutors are just not familiar with these cases and exactly how to prosecute them.
My name is Lisa Milot. I'm a professor of law at the University of Georgia, where I specialize in animal welfare. Prior to about 2017, there was some prosecution of cruelty, but it had stopped really being prosecuted. There weren't great outcomes with the cases, and so the then animal control superintendent believed, and I think rightly, that prosecuting under local ordinances was going to be more effective than under state law. But we had a couple of cases that came along that made two of the animal control officers at the time and me decide that we wanted to learn about animal cruelty and how to effectively bring cases. And so Princess Poppy was one of the first cases that we worked on. Cute, white lab, maybe 9 months old, came into animal control on New Year's Eve with an injury. She had some difficulty standing. She had a broken back and had had it for several days before coming into animal control. She most likely was a victim of trauma where somebody intentionally injured her. At the time, I had started and was running the medical program for the local shelter, so I went to the vet to see how Princess Poppy was, and the vet walked me through her examination showing that she had severe neurological issues. I was trying to convince animal control to let me authorize her to be euthanized. We could take her to a specialist and spend thousands of dollars and probably not have a good outcome. But animal control was telling me I couldn't have her euthanized because she had a known owner. And so I took a video of her standing in her metal cage at the shelter after her exam, just standing there and whimpering. She clearly was in pain. She was on pain control, but there was no pain control that was sufficient. She wanted to lie down, but she couldn't operate her body to do that. So she was just standing there whimpering. And so I took this video. That video became the reason, really, that the owner pled guilty to animal cruelty, because it was just so poignant and so powerful that the defense lawyer knew that he didn't want this to go before a jury. And so for me, it really drove home how important it was to collect evidence that not just factually shows the damage. We had x-rays. We could show photos of her lying in a yard, but the video of her standing there, I can't watch it even years later without crying. It helped me understand the role that emotional evidence can play in a case that could be made very cold and technical. It really is about suffering and the well-being of members of our community.
You know, the prosecutors are kind of the stars of the show in many ways, in the sense that they're the ones that kind of bring the case home. I'm not saying that because I am a prosecutor. I'm Sherry Hines. I'm a deputy chief attorney for the Unified Government of Athens-Clarke County, and I'm a local government attorney. I think a lot of people think that judges have the most power, that, you know, if a case comes before a judge and the judge doesn't think it's a worthwhile case, that he can just dismiss it, and that's just not the case. That's actually the role of a district attorney or a solicitor general who's prosecuting these cases.
Hi, my name is Alan Barber. I am the assistant director for the University of Georgia Law School's Practicum and Animal Welfare Skills Clinic. As a law enforcement officer, I write the report, I gather as much evidence as I can, hand that over to the prosecution.
I think the role of a prosecutor in animal control cases is, of course, to actually try the case, to handle all the litigation related to the case. Prosecutors have the discretion. They're the ones who have to either negotiate a plea agreement with the case or prepare it for trial and ultimately win at trial if you're not able to get a plea negotiation. But I hope that they will also be a good liaison with their animal services department, with their law enforcement, so that they can help those individuals develop the case before it fully gets to the litigation stage, so that the case can be as successful as possible.
Prosecutors should work closely with law enforcement, with enforcement agencies. My name is Jessica Rock. I am the Georgia statewide Animal Crimes Resource Prosecutor at the Prosecuting Attorneys Council. Prosecutors are much more prepared for drafting the indictment or the accusation in these types of cases and presenting them to a grand jury.
One of the big difficulties in prosecuting animal cases is that a lot of the evidence is really impenetrable. For example, when you get a necropsy, an autopsy effectively of an animal, the report you get back, it's really hard to make any sense of it. And if we just hand that report over to a prosecutor, it's really hard for them to do anything with it. The prosecutor, who is overworked, has a high caseload, and does not have a whole lot of time generally to spend on these cases.
You know, you're in court multiple days a week, sometimes every single day of the week as a prosecutor, hundreds, thousands of cases that you're gonna handle throughout a given year. It's challenging to motivate prosecutors if they're getting cases that they don't see very often.
Some of those prosecutors are just not familiar with these cases and exactly how to prosecute them.
If you haven't been able to collect the evidence that we need to proceed, then that puts us in a difficult position of, hey, we wanna go forward, we wanna win this case, but our chances of doing that are extremely minimal.
A lot of times the public thinks, oh, they just don't take these cases seriously or they don't care about them. But what I find is it's exactly the opposite, that, you know, animal control officers, law enforcement, prosecutors care very much about these cases. It's just when they lack the knowledge about how to investigate and prosecute them, it's a struggle. So a lot of it is making sure they get adequate training to know how to do these things. And when they do, you see a drastic change.
I think there's a lot of answers for why you should prosecute ordinance cases and cruelty cases involving animals. Inhumane treatment is something that we shouldn't accept in our community. That's not something that we want to be happening in Athens, Clarke County, and I imagine most communities would probably say the same thing. Secondly, though, I think there are a lot of good reasons separate from just the fundamental moral reason to prosecute these types of cases. One of them is, of course, that these are often sort of precursors or links to much more serious cases that the community very much has an interest in stopping.
They do not exist on their own. They just don't. We started realizing how many of these animal fighting cases were also connected to our gang problem, our cartel problem, our drug trafficking problem. Part of my role in that has been trying to dismantle these major animal fighting ventures so that we not only cut down on people that are fighting animals, but also people that are engaged in these other types of behaviors as well.
Knowledge of animal control ordinances and state laws concerning animals is a powerful tool for law enforcement in combating crimes involving humans. For example, drug dealing may not be immediately visible, but a guard dog tethered outside, in violation of local laws prohibiting unattended tethering, is. Knowing and adopting ordinances with an eye toward preventing crimes against people helps enforcement agencies do their jobs.
It gives police an lawful opportunity to go onto a property, to contact someone that we believe is involved in some sort of illegal activity so that we can you send that message, hey, you're being watched, you need to correct whatever behavior that is. Sometimes you're gonna discover much more serious crimes or potentially serious crimes that are also adjacent. And by having that legal reason to go onto the property because of the animal ordinance violation or the animal cruelty, you can help discover those other instances that you may also want to prosecute. First responders are in control of, essentially four things. They are in charge of the investigation of the case. They're the boots on the ground. They're the ones who have that potential to collect evidence and to ask good questions, to engage in critical thinking.
Just like with any scene, you're going to evaluate, do your victims here, because that's what they are, need to be rushed off to animal services or some type of vet service? Or can they be left on scene there for the time being at least so you can collect the evidence you need? You want to actually be able to get them to a vet first and draw blood.
Starved animals should be refed slowly. However, providing a small amount of food and capturing the animal eating it on video can be powerful evidence in a starvation case. Many times, a defendant will say that they gave an animal food, but they weren't interested in eating. But a video showing the animal wolfing down food shortly after they're found proves this is not true. Similarly, a timely video of an injured dog or photographs of their wounds can be the difference between a successful prosecution and a frustrating dismissal. It is worth the time it takes to capture the evidence.
The key evidence in most animal cruelty, animal neglect cases is going to be our veterinarian reports. What I found is that a lot of veterinarians are not getting exposed to good faith suspicions of animal abuse type cases in vet school. Equipping our veterinarians with knowledge of what is a good faith suspicion of animal abuse? What does the law in your state say? That's probably the key to a lot of these cases, is just having a veterinarian who does a solid report and who puts certain language in their reports that help us track that evidence in an indictment.
The second prong is collecting that evidence. I realize how challenging it is when you arrive at the scene. Tensions are high, or there's an injured animal, and it's hard to kind of slow yourself down and take the video or take the photos to document what you're seeing.
Water bowls, collecting chains involved. You can't just go take a pair of bolt cutters or something like that and just kind of start cutting them away. You have to actually preserve them in a specific way.
We're looking for clear information about the animal or animals involved. I want to be able to clearly identify that animal in court, or if there's multiple animals, I want to be able to identify each one of them uniquely, so that there's no question as to what alleged harm happened to what specific animal, and that animal is established to be owned by the person that I've charged.
And then also writing a very detailed report about what happened, how we got there.
Making sure that when you review your investigation, that you're able to present that to your prosecutor in a way that is compelling, that's persuasive, but also objective. In other words, we want to make it clear why we move forward with a case, but we also want to make sure that we aren't exaggerating, that we are sharing information in a clear and objective and defensible manner so that it will hold up if we actually have to take the case to the trial. For instance, we had a dog that was thrown from a car. And there was an injury when we were finally able to find the dog a couple weeks later. We needed the vet to be able to tell us, is this an old injury? Or is this a really recent injury? Like, could this have happened totally unrelated from being thrown from a car? We all want to jump to the conclusion, dog thrown from car, probably broke a leg. Like, that's a very reasonable conclusion, but that isn't sufficient for me to prove it in court, especially if a vet could come in and say, actually, no, this looks like a much fresher break. It probably happened afterwards some way.
And so one of the things that my students and I work on is that we write plain language summaries of veterinary evidence for these cases. And we coordinate with Dr. Miller, who is a top forensic veterinarian, and she oversees many of the necropsies we have done here at UGA. We work actually with vet students who are interested in forensic veterinary work to be able to describe the injuries and illnesses of the animals that are the victims in these cases in a way that the prosecutor, the defense counsel, and frankly, the defendant can understand.
The first person to usually get a copy of the report is the defense attorney or the defendant. And so I tell law enforcement, I know it's like the hardest part of their job is sitting down and, knocking out a good, well-detailed report, but it's actually one of the most important parts of putting together a good case, because that is how the case is going to be judged.
One of the things that we work on the most with animal services officers is how important it is to take the time to write out everything that you have observed, everything you thought was important, everything you did and why you did it in your report, because the number one rule of any kind of litigation involving law enforcement is if it wasn't in your report, it didn't happen.
Depending on the scale of the investigation, it can be difficult to put all of that in a report that's easy to understand. But that is one of the most crucial parts of investigations is having that dedication, that skill, that time, and that ability to put all of the information from your investigation in a clear and convincing report that helps the reader understand the significance of the case if that's the first thing they do is read that report. And then obviously there's just putting all of that together. So being sure that the investigation was done within the legal bounds of the law appropriately, the evidence was collected, the evidence was processed, and then of course writing a good report and putting that whole package together and making sure that that information all gets to the prosecutor.
So that when it does go to court, that you're prepared, that they're prepared, and it's working with them to make sure that they know what questions to ask. The investigator then becomes that kind of expert witness. You were the one that was there. You were the one that can kind of tell the jury or whoever's involved, whether it be the jury or judge, what that scene smelled like, what it sounded like.
One of the first things that I do when I'm assisting prosecutors with these cases is I always say, did the animal go to a vet? And do you have copies of those vet reports? And I find that a lot of times, unfortunately, they don't. So I'm like, okay, go track down those vet reports, because that will help you articulate your charges.
There are two types of warrants that can come up in these cases. There are arrest warrants, which is probably the more common thing that you may be asking about, and there's also search warrants.
Search warrants have to be very specific, and if they aren't, we will lose ultimately the ability to present all of our evidence to a jury if that search warrant was not very detailed and procedurally processed the way that it has to be.
Statutes within Georgia lay out specific elements to each crime. Animal cruelty is no exception to that. You have to be able to interpret that and then articulate that within an arrest warrant to be able to actually file formal charges.
And then, of course, we want to make sure that we are being objective. We're not being emotional about these facts. I think it is fair to say that judges begin to know the people who come to them with warrants. And if they begin to doubt your credibility, even if it's just one time that you exaggerate or you don't do a good job kind of verifying your facts before you come to a judge for a warrant, can seriously imperil your ability to get warrants from that judge in the future. So whenever we're drafting an indictment or an accusation, we want to be clear as to what the person is charged with. So the law requires us that when someone reads that document, they should be placed on reasonable notice as to what they're being charged with. What is the crime? When did it happen? And then we often use some of the actual language from the crime itself. On a collar firmly affixed upon this particular dog's neck at all times, because that's what's required by the statute. So it'll reference the statute and it'll also include a description of the dog. One of the challenges that we sometimes run into is that we need to be specific about the animal such that it's clear what animal we're talking about, but we don't need to be so specific that we end up in a trial where we're fighting over whether the dog was named Fido or Bruno. I wouldn't just put a brown dog, unless that is literally all you know, but I might not put, a neutered male or something like that. Then you get in a fight about whether that's really relevant or material to the indictment. When we do indictments and accusations, and I think it's important to make sure that you have specific and separate counts for every single animal, for every single charge. You may merge some of those later, you may dismiss some of those later, but making sure that it is very clear what is being charged for every single instance is incredibly important. But just making sure that the person can't argue that they weren't on notice and that you are in fact charging a crime, right? We want to be careful that we don't include language that isn't relevant to that specific code section that you're charging them under.
Malice or maliciously is most often in our state animal cruelty statute the difference between a misdemeanor and a felony.
Sometimes we do have cases that rise to torture or to a situation where an animal has been put in extreme or continuous pain. An animal services officer or prosecutor needs to go back and look at each element of either the statute or the ordinance to make sure that they're actually matching the evidence or the facts kind of on the ground with the case itself.
We had I hate to even talk about the horrible facts of the case, but he had hit his own dog over the head with a sledgehammer. We went to trial, and his defense to the jury was that, well, my dog was just suffering a lot. So yes, I did hit my dog over the head with a sledgehammer, but I wasn't doing it maliciously. I was actually trying to help. The jury basically said, can you explain to us what the word maliciously means?
Prosecutors don't necessarily want to move forward with misdemeanor cruelty when it's sort of a lower level. But the law actually does allow you to move forward with certain types of basic neglect cases, even if the person isn't particularly malicious, isn't particularly trying to hurt the animal.
Pursuing a charge of cruelty, which is a state-level offense, may be an effective strategy, even if a local charge applies. Local convictions don't stay with the defendant. If the defendant moves out of the county or the state, a local violation won't follow them. A state-level offense will still show on a background check. If the person does the same thing again in another jurisdiction, that prosecutor and judge will know they have a repeat offender.
We have, in our statute, two basically different components of malicious. We have like an actual intent, which may be shown by circumstances connected to the act, and then we have, if you want and willfully do an act with an awareness of a plain and strong likelihood that a particular harm may result, then we can also charge you with a felony. Most of the time we're dealing with animal cases, we're not dealing with the actual intent, we're dealing with the want and willful doing of an act or failure to do an act that leads to some type of harm.
In ordinance cases, it can vary greatly depending on your local ordinances. So a really good example is really reading your specific ordinance to make sure that you understand how it's applied. And so we had some trouble with our local tethering ordinance for 2 reasons. Unlike all of our other ordinances, it said that it is illegal for an owner to tether the animal. Our judge correctly has read that to mean affirmative tethering. Like, we have to prove that you actually went out and put your animal on the tether, as opposed to maybe your wife did it and you just allowed it, or your friend did it and you just allowed it and didn't do anything about it. Or does it specifically require the owner to have taken an action? And if so, you better be prepared to prove it. And that's a much higher burden than just proving that the owner knew about it and allowed it to happen.
Prosecuting a crime involving animals can be intimidating. Prosecutors, law enforcement, and animal control officers are rarely trained in all the areas needed to prepare these cases for successful prosecution. The evidence required is different than in other kinds of cases, so ensuring it is collected quickly and clearly presented helps a prosecutor understand, prioritize, and resolve the case in a satisfactory manner. In Georgia, the vet with whom you work on state-level cases, cruelty, dogfighting, and lack of humane care, should be accredited, meaning they're able to sign health certificates. Having a vet who is willing to do blood work, fecal examination, and basic physical exams immediately is often critical to collecting and preserving evidence. Additional diagnostics and care may need to wait, but both blood factors and body condition evidence will be destroyed quickly because the animals will soon be fed and medicated as needed. Most vets aren't trained to know what is needed in every case, but they can do research if they know what to look for. Explain the relevant legal definitions to the vet and ask them to apply the facts to those definitions. Remember that vets are not trained in the law, so they may apply lay definitions to terms like cruelty or malice instead of the relevant legal definitions. Or they may be uncomfortable using terms like suffering because they're often trained to avoid anthropomorphizing animals. Just as legal terms may be alien to a vet, veterinary descriptions of conditions can seem dense and technical to a layperson. Ask the vet to explain their findings in plain English. Then use this description in your case summary to help a prosecutor readily grasp the facts of the case. A summary cover sheet can go a long way. This cover sheet includes the case basics, evidence types, the defendant's basic information, a list of witnesses, their contact information, and what their testimony will entail, as well as your suggested resolution. While case reports, witness interviews, extensive photos and videos, and vet reports are all important evidence, making them easy to digest will help your case stand out. Include relevant case law, tie specific items of evidence to each element of the offense, and include the plain language summary of the veterinary evidence after review by the vet. These materials should be delivered in advance of arraignment and in one package. Review the evidence in advance and follow up with the prosecutor. Local law prosecutions are often more sure and yield more immediate consequences. State law can more easily include strong deterrents for future offenses, such as arrest, imprisonment, and longer prohibition on animal ownership or possession. Georgia's state cruelty law also has an escalating structure, in which a second offense is a felony, even if the actions would otherwise only qualify as a misdemeanor.
A lot of times people are hesitant to collect evidence in animal cases, depending on how far the case goes in the process. And if we're in front of a jury and we thought something was important enough to be a part of the case and was evidence in the case, we should not be leaving it at that crime scene.
There may appear to be an easy answer to what is happening. That is not necessarily the correct answer. So making sure that you go beyond, initial assumptions, you talk to witnesses, you think critically about whatever evidence is in front of you rather than jumping to conclusions is incredibly important for getting a good resolution at the end of the day.
Understanding the animal crime statutes, our animal sexual abuse, our animal fighting statutes, our animal cruelty statutes, our animal abandonment statute, our state laws, understanding our city and county ordinances, if that's the realm of investigation or prosecution you do, is crucial to us changing things, not just for animals, but for the humans who care about these animals. The more people start investigating these cases and prosecuting these cases, the more they start seeing for themselves that that is a reality.